Now let's turn our attention to remedies. And we'll start with buyer's remedies in the event of a seller breach. Now the buyer has several different remedies under the CISG. It has a right to performance, which we refer to as by the concept specific performance, meaning the buyer can require the seller to conform to the contract, to do what it is the contract obligated the seller to do. The second is a right to avoid the contract, what in the common law we call rescission. In the CISG we call it avoidance. And basically what rescission does is it puts the parties back in the position had the contract never occurred. So a buyer could ask a court or an arbitrator to avoid the contract, which is to make it as if the contract never existed. Sometimes the buyer has a right of price reduction, and we'll talk more about each of these in turn. And then, of course, a buyer has a right to money damages in the event of a breach by the seller. Now, as background to all of these remedies, understand that the law is going to place a duty on the buyer to minimize his damages. And we call this the duty of mitigation. Mitigation means reducing your damages as much as possible. And what it says is that if you, as a buyer, have been harmed by a seller's breach, the obligation, now have an obligation to minimize your damages. You can't simply stand by, let the damages roll up, and then sue the seller for the entire amount of damages. Instead, buyers have a responsibility to go out and purchase substitute goods. And we call that purchase of substitute goods, we call that cover. So a buyer has a responsibility to cover. If in our hypothetical situation, the buyer is a manufacturer in Kansas who's going to assemble bicycle frames, and the company in China from which it's going to purchase the bicycle frames breaches the agreement, fails to deliver it, the Kansas company now has a duty to go out on the market and purchase substitute goods, another source of bicycle frames. Now those frames may well be much more expensive than the original contracted for frames, but that permits a court to calculate a remedy. In this case, the remedy will be the difference between the cost of the bicycle frames as they were in the contract and the cost of the substitute bicycle frames. So mitigation, the duty to mitigate. So all these remedies we'll study, and it works the same for the seller. Both buyer and seller have a duty to reduce their damages as much as possible. Now let's turn back to the remedies. And we started with specific performance. Now specific performance in common law countries is rarely available. In common law countries, courts don't like to require people or businesses to perform. A court would much more likely to prefer to order a company to pay money, to pay a breaching party. The breaching party must pay money damages. Now, this is not the case in civil law countries. In civil law countries, there's definitely a preference for specific performance. Do that which you promised to do in the agreement. Now, the CISG allows for specific performance. And what happens is that in civil law countries, under the CISG, courts tend to award specific performance. In common law countries, even though they're applying the same body of law, they're much less likely to award specific performance and much more likely to award money damages, which, as we said, is another possible remedy. Now, in common law countries, specific performance is very rare, and it's only available where the money damages cannot be calculated or seem to be inadequate. Essentially, when the subject matter of the contract is unique. So if you make an agreement to purchase someone's Toyota Camry, and that party refuses to sell you the Camry, then the court is likely to award you the difference between a substitute Camry that you bought and the contract price for the Camry you had originally agreed to. Now, if that vehicle is not a Toyota Camry, but instead a very limited edition Ferrari, in which the purchase of substitute goods may not even be possible, even in a common law country, they're likely to award specific performance. Now let's turn to the right of avoidance. Now, avoidance is a buyer's right to avoid a contract, to set aside a contract where the seller has committed a fundamental breach. It is an early termination without the need for court intervention. Now, avoidance differs in that it releases both parties from their obligations to perform. Both parties can declare a contract avoided, which means neither party has any obligations under the contract. If a contract is avoided by the buyer cannot later sue the seller for breach of contract, because avoidance means the parties are going to be in the position they would have been in had the contract never occurred. Now, avoidance is only available in the case of fundamental breach. So there must have been a fundamental breach in order for a buyer to claim the right of avoidance. The seller can have a right of avoidance as well if the buyer fails to take delivery or to pay the purchase price, any sort of fundamental breach. In that situation, the seller could also avoid the contract. But much more likely that a seller will seek money damages rather than simply attempting to turn back the clock to before the contract existed. Now, the other remedy we talked about was price reduction. And if the goods were not of the quality or of the specifications called for in the contract, the buyer may elect to keep the goods as delivered and to withhold a part of the purchase price in order to offset the reduced value of the non-conforming goods. Say a company is purchasing hard drives. They want flash drives, and they ask for 256 gigabyte flash drives. They receive a shipment of flash drives which are 128 gigabytes. Now, the company may wish to use those, may still be able to find a use for those, but they're not what was called for in the contract. So what the company can do is elect to keep the goods and then pay a smaller amount, pay the price that they would have paid for 128 gigabyte flash drives. So that's the right of price reduction. Now, the last remedy we're going to hold off on is money damages. We'll take that up in the next lecture as to how to calculate money damages. Let's turn to a seller's remedy for a buyer breach. Now, the seller's remedies are very similar. There is a right to performance, specific performance, which in the case of a buyer breach really means pay the contract, pay the price. Usually payment is the right to performance. The seller has a right to avoid the contract, rescind the contract in the case of a fundamental breach. The seller has a right to cure, and again, we'll talk more about cure in a second. And the seller also has right to money damages. Let's look at each of those in turn. We'll start with specific performance. The seller can demand performance according to the terms of the contract. However, keep in mind that the seller also has a duty to mitigate. And a seller's duty to mitigate is what we call resale, meaning if the buyer fails to take delivery of the goods, then the seller has an obligation to go sell those goods on the market. Now, the seller's remedy is going to be the difference between the contract price and the resale price. So in this case, if the seller, in our hypothetical, if the seller is the Chinese manufacturer of bicycle frames, and they are notified by the Kansas assembler of those frames that they will not take delivery of the frames, the seller cannot simply sue the Kansas corporation for failing to take delivery and then ask for the entire amount. Instead, the seller must go out onto the open market and attempt to resell those goods, to sell them to another buyer, to find a substitute buyer for the goods. So we call that resale. Remember, the buyer's obligation is to cover, the seller's obligation is to resell. Now, under avoidance, again, a seller has a right to avoid a contract if the breach by the buyer constitutes a fundamental breach. But remember, the seller can take advantage of this not-frisk period, this cooling-off period, and the seller can give to the buyer an additional amount of time in order to pay or to take delivery. The last one that we're going to talk about, again, holding off on money damages until the next lecture, is the notion of cure. And cure is a specific term that says this: where a breach is not fundamental, a seller has a right to cure its performance, its failed performance. So a seller has a right where it is failed to perform, it may cure its failure to perform by furnishing the goods, conforming goods, as were expected. Now, the seller's right to cure is dependent on it must be done at the seller's own expense. There cannot be any additional charge to the buyer. But the seller can remedy any failure to perform his obligation. And the seller's right to cure may void the buyer's right to price reduction. So going back to our hypothetical where the seller has shipped 128 gigabyte hard drives instead of the 256 gigabyte hard drives that were ordered, if the buyer says, no, I'll pay you a smaller amount for these hard drives, the seller has the right to fix that performance, to cure that performance by shipping conforming goods. So if the seller, even if after the time for delivery has passed, if the seller delivers those conforming hard drives, then it is likely to recover the full amount of its contract, the contract price. So a seller has a right to cure, and that right to cure may prevent the buyer from reducing price. That's it for this lecture. In the next lecture, we'll talk about damages as well as defenses available under the CISG.